Hello. So, good afternoon, friends. A very good afternoon after very healthy snacks and wealthy and humorous session of Vimal sir. Uh, 25 years of sir, 2,500 lectures by sir. Vandana Dhodia also completed 25 years in this study circle. Almost silver jubilee मेरा खुद का भी हो रहा है. I also मतलब nostalgic. In year 2000, I became convener of this study circle. I remained convener for 5 years, 2000 to 2005. I've seen the journey from 50 to 500 members, and today we are 1800 plus members. And we are the one of the best study circle in all over India. Highly recommended study circle. Good at studies and extracurricular activities also. We also have sports. So, we all like to keep engaging our members, and we also felicitate new members when they qualify and they join us. And now coming to देखो लाइफ का भी असेसमेंट होना चाहिए, वैसे इनकम टैक्स का भी असेसमेंट होना ज़रूरी है. When we are heading towards the time bar returns assessments and everything, I think in these 3 days tax series, first of all clap for Ravi Soni and the team. Why I want you to clap for Ravi is that conveners और स्पीकर कमेटी बैठ के डिसाइड करते हैं कि हमें कौन सा टॉपिक लेना है. अच्छा, दिसंबर एंड में ज़्यादा करके सीपीई के लिए लोग आते हैं. दैट इज हाउ द ट्रेंड ऑफ WRC इज टेकन. बट हियर इन आर स्टडी सर्कल मेनली पीपल कम फॉर द स्टडीज. दैट्स आई कैन वाउच फॉर दैट. मे बी फ्यू पीपल फॉर सीपीई, बट कुछ तो वो लोग सुन के ही जाएंगे. Also, Ravi has started a trend that he will record the session, so those who could miss due to some preoccupation will be able to get that knowledge later on also. So one more clap for Ravi. And the team. Whenever I say Ravi, it is implied BCSC is always a team. And no organization can run in any family also. Everybody is supporting each other. So we are here for you, Ravi, don't worry. That's what I wanted to tell you. And thank you, Ravi, for supporting me today. And now coming to Nikhil. So formal introduction, I will request Shreyans. Prior to that, I just want to say कि when the time bar returns are coming, assessment के time पे क्या ध्यान रखना है, reassessment के बाद भी आपको क्या ध्यान रखना है, वो सब चीज़ें हमें आज हमारे निखिल सर बताएंगे. So over to you, Shreyans, for the official introduction.
Thank you to give this opportunity to introduce our today's speaker for the second session. CA Nikhil Tiwari is a partner at SR Batley-Boy. It is a member firm of EY Global based in Mumbai. He's a rank holder from 2007 batch and has more than 18 years of experience in handling direct tax matters before various appellate tribunals, litigation advisory in the field of corporate tax, international taxation and transfer pricing for several multinational companies and domestic clients in a wide range of industries. He has been actively involved and regular speaker at internal as well as external forums, including ICAI, BCAS, Chamber of Tax Consultants, etc. on technical and non-technical topics. He has co-authored various articles and publications on international tax and transfer pricing. With this, requesting members to welcome our today's speaker with a huge round of applause, CA Nikhil Tiwari. Now request CA Vandana Dhodia to present the memento to our today's speaker.
Good afternoon, everyone. See, I have taken today two topics. One is assessment, second is reassessment. And in fact, I want this session to be interactive. As many as questions you have, whatever you want to ask me. I don't want to be here at desk. I rather want to be with you and take this session so that I don't want you wait for my sessions to end and then ask questions. In fact, first session I had occasion to hear few minutes I was there, and I am glad that everyone wants to understand this and have that kind of participative nature. So with this, before I start my sessions, two or three important things. See, I am from the litigation background, so let me tell you, I am going to refer few of the case laws as well. When I will refer those case laws, I will advise you all when you are, because this presentation is going to be shared with you, when you all going to refer this or take use of that, always keep that in mind that you have to marry your facts. You just don't blindly apply those case laws to your set of facts and use it. That Nikhil has said in this session that something like this will work, so this is the case law and I'm using it. Never do that. The only ratio of that case law is binding, not the entire case law. So you have to first see what are the important facts, basis which the finding is given, and then only use that case law. Second thing, I am today going to take a session which is on a procedural law. There is a separate rules of interpretation for procedural law. Please keep that in mind when we will discuss this session. This is not a charging section, this is a machinery section. How it will work, what is the rules of interpretation, what kind of amendment can come into picture and everything. If we keep that in mind, some of the principle which we normally keep in mind, look, if there are two view possible, one which is in favor of the SSE, if something is not workable, entire tax liability will not come into picture, all those things will go out of the net. Because here, the primary rule is, the court will always say, if procedure law is not workable, let them give an opportunity to work it out. The classic example is Supreme Court in case of Ashish Agrawal, wherein everyone, all the high courts, all the even in fact the Supreme Court was clear that the department has goofed up. The amendment, TOLA, everything has come in such a manner that there are two reopening provisions working at the same point of time. So one has to be quashed, but still they have given their lease of life because there was a procedural which is involved. They said, okay, you argue on the merits, let this procedure be given a fresh life. So keeping that in mind, in fact, if you see my slides, it is running into 136 slides. I am not going to take all the slides. After slide 50, I have given a case laws of, because one of the topic is reopening, and there is so many things happening in reopening. For reopening, there are at present 5 laws which you have to keep in mind. One law prior to 2021. What was the provision? Because you might have to go and argue for some appeals. You might have to go some CID for your clients. You might be doing some 263 against 147 order. So you have to see the 147 order passed when, for which law. One law post 2021 till 22. Why till 22? Because 22 they have again changed the various definition in 21 law. So when your reopening has happened between 21 to 22, you have to see a different law. Then third is 22 to 24. Again 22 to 24, subject to some tweaking in these 2 years, law remains the same. Then you have to see it is whether post 1st October 24. Again, Finance Number 2 Act 2024 has changed that law. Everything has gone, and whether it is happening under the new Income Tax Act 2025. So all those things has to be kept in mind. And some slight change in facts, slight difference in situation, answer will be different. You can't have, this was explained, I might have explained for the situation 1, year 1 law. Now there are 5 laws which is running in parallel, and you have to see what is applicable for which law. Sorry. So in fact, I had occasion to listen to sir what he said. Few things which before I start, which I could hear and I have something to say. So I thought rather than keeping to myself, I will say. See, if someone has asked about the WhatsApp chat, what is the this thing sir has rightly explained that law under the new 2025 Act has already taken care of that. In fact, there is a Mumbai tribunal decision passed recently, and they discussed about what is the legal sanity of this, whether the WhatsApp chat per se will be regarded as evidence in the lies of uh, Income Tax Act, and they have find out a via media route. And the via, so the decision is very detailed speaking order. I don't remember the name. I will share with the conveyor, and he will share with you all. The decision is going on the ground issue that whether WhatsApp chat, which has been used to make an addition in the particular SSC's case, whether that can be constituted an evidence. And for that, they travel to the Information Technology Act. And for that, there are two important things which is necessary for any digital media or digital evidence to be regarded as evidence. First, whether the original copy of that, or either mobile per se, is present before the officer at the time of recording this. If not, the certificate they have to obtain under IT Act 2000, Information Technology of 2000. Either of two has to be present to be regarded this WhatsApp chat as evidence. All other things sir has rightly pointed out. Even though you say it is evidence, but thereafter you have to marry this with the actual transition of facts and all those things. That is a different thing. But at present, the tribunal has taken a view which normally no officers takes. You don't take your mobile per se with them at the time of passing the order, or even their mobile is not seized for them to take at the time of appellate hearing, or neither they obtain this certificate under the IT Act, which they cannot take post facto. So now once the tribunal order come, they might be aware of this and they might take it henceforth, but nevertheless, as sir said, it is already taken into account in 2025 Act. Yes, sir. Correct, correct. Again, same thing will happen. Backup is fine. In fact, there are, I don't want to venture into this because this is sir's topic and I have a different topic to take. But nevertheless, there are various ways in which SSC is mitigating this. But again, that is not my topic of interest today. And again, if you take the backup, backup per se is not the evidence. The original device from where you have taken that. If not, then you have to obtain a certificate under the IT Act. If that is not present. So this is a threshold. The tribunal ruling is a threshold. That at threshold itself you cannot regard as evidence. Let's assume if this decision is not there, it will be evidence, WhatsApp chat, but still you will not be able to take addition because thereafter is the cache. Only some WhatsApp chat or some third party confirming something, all those things are different issue. But tribunal has gone on the threshold. Whether per se I have to look into that WhatsApp chat or outrightly I can reject it. That was the point for which I thought let's speak for 1 minute. See, my topic today starts with assessment. In fact, more than me, you all will have experience of attending the assessment because I don't attend any assessment. I go in appellate proceeding post assessment, either in CITPL, DRP or tribunal. So here, though I will speak from my experience because post assessment everything comes to us, but I will encourage if anyone has any different thought, if someone says no, what I am speaking is not correct, that is not in my experience, then please come into picture. See, assessment include reassessment. In the new act, assessment includes reassessment plus recomputation. All those things plus minus here and there is not making any difference. Now in this slide, I want to speak of two things. First, the Supreme Court decision. As I say, I am from the litigation background, so I am more or less inclined to speak about the court decisions. The first Supreme Court decision in case of Kalyan Kumar Ray. This decision rendered very long back, but still have so much of value. I will explain why. It says, see, assessment involves, again, this was a PIL file to get something corrected, and Supreme Court has not corrected anything, has not quashed or not, but he has explained the procedure of assessment. And in fact, we use this decision so often. The decision says the assessment involves 3 steps, and unless all the 3 steps are completed, assessment is not completed. This is the first thing. Second, these 3 steps which I will speak has to be in the same sequence. If you miss this sequence, again it is wrong. What is these 3 steps? Step number 1, passing of assessment order, wherein your income will be determined. Step number 2, computation of tax liability, that is ITNS 150 and now whatever name it is called, wherein your tax liability will be determined. One, income determined, second, tax liability determined, third, demand notice, wherein your final liability to pay will come into picture. If all those three is not present in the assessment order, your assessment is not complete, invalid, it cannot enforce. All three has to be there. This is what the Supreme Court says. Now, in fact, in last 10 years, this decision is very frequently used by all the taxpayers. If you all are aware that in 2009 there was a provision of DRP which came into the statute book. Now, earlier there was a concept of passing a draft order which was done away with. Now, post 2009, again for two kind of assessee, one who is a non-resident, second in whose case transfer pricing provisions are applicable. If either of two is fulfilled, you can opt for the DRP route. For DRP route, first you have to pass a draft order. Now, this decision has been used where along with draft order, wrongly he issue a demand notice. Wrongly, everything is draft, but he issues 156 order, 156 notice about the courts, so many high courts, including our jurisdictional high court, has concluded that this is assessment is concluded because Kalyan Kumar Ray says 1, 2, 3. You come to step 3. Step 3 is the conclusion of assessment. Once assessment is concluded, you cannot say it is a draft order. It is nothing but a final order. Now, if it is a final order, their assessee took the advantage to say that important right which was given by statute to pass a draft order has not been given to me. Everything is bad in law. They were able to succeed. So again, I said this decision has had so much of utility. Now, in this forum, what is the utility of this decision? I don't know whether anyone examined this. If you see any order of your client, now it comes in through a ITBA portal. The ITBA portal, again, I would request everyone, some slight deviation from it, just go to 2018 and 2019. This is very relevant, very important. See, because someone, when I joined this profession, someone told me, and which I didn't like, was when you go to any CA, they will tell you how to comply with the law. But when you go to any advocate, he will tell you how you can mitigate this law and you can come out of this law. I think that is not the correct way of looking at it. Even in fact, as a CA also, we should be able to convey our client what is the correct position of law, even though you comply with it, but keep your rights and this thing open. Why I'm saying this? If you, and I'm therefore urging everyone, please read this notification which came in 2018 on how ITBA portal, how digital signature, everything will come into picture. This is running into some 10-15 pages, but it is very relevant. Why relevant? One or two example I will give. Again, I don't want to deviate from my topic, but still, if you see any assessment order, there is a digital signature at the bottom of the page. Last page, assessment order, 3 things will be there. One, even sometimes separate penalty notice. 4 things will be there. If you see in all the page order, assessment order, notice of demand, ITNS computation, at the end of the page there will be a digital signature. The digital signature will also tell you the time, date. In time, they will tell you the hour, minutes and seconds. On the first page of order, on the last bottom of the page, it says the date of the assessment order is date on which it is digitally signed. That is the footnote given in the order, if you see any order. Invariably, this is my experience, and I, being in litigation, I have taken this before the court, it is yet to be. Invariably, if you see the assessment order, they generate the demand notice sometimes prior to the passing of order. Some few seconds, but yes. They generate the computation sheet prior to passing of the order. In some cases, it is even the delays of 20-25 minutes. See, the law is very clear. How can you generate a demand notice without any underlying order? Your demand notice has to have a underlying assessment order. So that has to go in sequence. If it is not in sequence, at that particular point of time, when you pass the demand notice, there was no underlying order. Your demand notice has to be quashed. And once the demand notice is quashed, your assessment order is not followed by demand notice. assessment has to be quashed. So this is one thing. There are, in fact, if you see post intersection of ITBA portal, there are more than 20-25 things on which you can speak. Because of their own procedure, they have goofed up. So these all have to kept in mind when we speak about the assessment order. When it comes to you, you have to see this. Sometimes this is practically happen and matter meant to the court. Your date of order is within the due date, but your digital signature is after the due date. Your footnote says your date of order will be date it is when it is digitally signed. Don't go by date which is mentioned on the first page of the order. Just see when it is digitally signed. Even if it is missed by some few seconds going into next date, it is on next date. For order, you have to take that kind of this thing. So just don't go by it has it, the order is passed, all the three documents come, someone has digitally signed, so it must be a proper order. Again, so I don't want to speak about all those things, procedural laws, because we will then divert from the procedure of assessment. We will go into some different topic. I don't want to go into that topic, but nevertheless, if anyone has any experience, wants to speak about on that, we can speak. Correct. Sir is right. So sir's point is, in a procedural law, if you find out any lacuna, whether the ruling which I have explained just now in case of Ashish Agrawal Supreme Court will come into picture in all type of these cases. See, Ashish Agrawal, what has happened? There was a blunder from the parliament, not from the assessing officer. What blunder parliament has made? From 1st April 2021 till 30th of June 2021, there was a two reopening law which was made applicable. One, unamended pre-2021. Second, amended 2021 law. 2021 law kicked in from 1st April 21. Unamended law, which was a prior law which was repealed, because of TOLA, it was extended from 31st March 21 till 30th of June 21. So for these 3 months, there was two reopening which was parallelly going on. So which law I will apply? Which law assessing officer will apply? Now because of that, some mistake officer did. All the officer taken a view that in this 3 months period, old law will kick in. New law has not come into picture because TOLA has given extended to old law. And then when SSC went and says whether notification can override the provision of the act. The act says it is already new law kicked in. You are by view of a separate notification which is again codified. Who will proceed which one? And if this mistake has happened, whether some fresh life has to be given. That was the issue. Now, there is no ambiguity in the provision of the act. Now you have to give effect to the order. It is very clear and settled law, principle of law, that no one, even the court does not have power to extend the time limit to pass the order. Whatever time limit is given is sacrosanct. Second thing, all may be aware so much of fraud going on with regards to, you may be aware, US tax frauds, wherein people sitting in Mira Road are issuing the orders and blackmailing the people and everything. See, when you received any kind of documents and information from the assessing officer, that has to be sacrosanct. So for that, various safeguard is given in section 282, 282A, the manner in which it is to be passed, the who has to pass this, whether that person has authority to pass, and all those things. And at the same point of time, it is to be passed within the time limit allowed. If it is not done, whether it is a procedural mistake or it is without any authority of law, that is the issue. To my mind, it is without any authority of law. If that position is taken, some mistake here and there has to be taken, then in all these cases, the officer will be very lenient. And he will continue to make such kind of mistakes. Again, let me take you the flip side of this. You might be aware, when we file a return of income, so much of pressure on the portal. Sometimes we, because of this, we file just 5 seconds late. It goes to the next date. And we went to the court, says, look, this is the problem happened. Now you treat this return as within time. Court says yes. No, but law is totally different. When it comes to the SSC, they will give this benefit because we are not the person who has created the system. We are subject to this system. The officer are the people who are working and they have created, or the income tax department or the government has created the system, so they cannot take any advantage of issuing the system. This might be because of system, something coming prior, not signing and all those things. So there the courts take lenient view. But when it comes to the officer, he has to. If it is not there, there are so many procedures given in the act. You comply with that. You take DG systems approval, you will be able to take all those things. All the approvals. But if you miss it, I think we will have a good case. So again, at the same point of time, you all must be aware of the DIN controversy which is going on. I don't know whether you all are aware. Just briefly, I will speak about that, and then I will come to because in the assessment, in old and new law, there are no much change. But at the same point of time, I want to educate you all with my experience, whatever we have, on how we should tackle effectively this kind of assessments. See again, 1st October 2019, there was a instruction issued by the CBDT, which says any order, notice, anything, even an internal communication between the department with regards to a particular SSC have to have the DIN number. Now for having a DIN number, you have to first upload an order in the ITBA portal. Now if you upload the order in the ITBA portal, your order will have 4 or 5 different unique things. First, you see the background watermark will come. Income tax का logo आता है उसके अंदर. There will be a barcode. You can scan that barcode. There will be DIN number. This all, if it is there, then you can be sure that this has come with the ITBA and a digital signature. You cannot have an order which is coming from the ITBA portal and it is manually signed. It has been done by the officer. I will come to that, but these are all the this thing. This circular came in 2019. Matter traveled to various courts. First one was the Brandix Delhi High Court. Delhi High Court taken a view that if a particular order is not having a DIN, has to be quashed. It is to be quashed because the instruction itself says if this order does not have a DIN, it is nullity in the eyes of law. If it is nullity in the eyes of law, it has to be quashed. In fact, there is a even someone might have seen, there is a video circulating wherein the FM itself spoke in some of the forums that if you get some kind of orders, please trash and send it to dustbin. You don't have to reply to that kind of thing. Nevertheless, some Bombay High Court also passed the order in favor of the SSC Ashok Commercials. Various other high courts have passed the order. Matter went to Supreme Court. This Brandix case was represented by the council. The Supreme Court, on a department's argument without even hearing the SSC side, has stayed the operation of Brandix. This is the stage at which it is there. They have not even looked into this, that look, this is not the brainchild of the High Court. This is the brainchild of department. They have said this and High Court has merely followed the instruction. What is the wrong in the High Court order? But the department council has pointed out, look, this is impacting so many cases, all those things have huge implications. So they have stayed the operation of the Delhi High Court. But recently, Bombay High Court in case of Siemens, just 1.5 months back, when this issue was pointed this out, including that it is stayed, Bombay High Court says see, there is a difference between High Court order being stayed vis-a-vis High Court order being reversed. Still Bombay High Court has followed that proposition and quashed the order which was having without them. So again, as I said, if you read this 2018-19, the entire mechanism in which the ITBA portal came into picture, these all arguments come from there. And it has to be taken, depends on what is the stake involved in my client's case. If I feel that I have a weak fact and I have to protect my client, these all are the avenues available. But at the same point of time, we just can't rely only on these arguments. In fact, still a case is going on wherein manual signature is there, but digital signature is not there. Whether it is correct or not, court has struck down in some cases. Some cases it is still contemplating, yes, okay, some signature is there, so it has to be given. Now I was saying, there is a rule which prescribes mode and manner in which you have to communicate the assessment order. Why we have to see this? See, if you see the 153 section which talks about passing of assessment order, it doesn't say it is to be served on the assessor. Only notice of demand has to be served on the assessor. It says 156, notice of demand has to be served. 153 doesn't talk of that. 143 doesn't talk of that. Notice of 143.2, yes, has to be served on the assessor. 153 says no order of assessment shall be passed within 21 months. So what about whether it is to be served or only pass करके रख दिया बस हो गया? It has to be served. There is a manner and mode given in which the communication has to be given, served, in which email, ITBA portal, uploading on portal, and all those things comes into picture. See, practically, again, the issue has come because of the amendment in section 282. When this electronic form came into picture, they amended that section. Says it has to be signed and issued. In manuscript, it was earlier there, signed and issued. Now they have included the electronic form of communication as well. So in few of the cases, the 148 notice case was there before the High Court. Department has not signed neither manual nor digital, and matter went before the court. The issue before the court was whether this kind of order notice is valid or not. Department's argument was, look, it is communicated in the proper manner. Came in your ITBA portal or through email, correct email ID, so it has to be valid notice. And all watermark, barcode, everything was there, but it was not signed. The court says, look, the section says two things, has to be signed and communicated. You can't say it is if it is a properly communicated. As I was saying, the same cases which was happening from USA and someone sitting in India doing the fraud and sending this thing. How can I be sure that this is the same assessing officer who is giving me this? Has to be signed. You can't say there is any substitute of not signing. Even if it is practically till now, many notices issued through ITBA portal is not signed. I don't know how it is happening, because what is told to me, if we have to issue something through ITBA portal, has to be digitally signed. But if you see even still some 148 notice, it is not signed. Now there is a different treatment for different kind of notice. If you say 148 notice, 143.2 notice not signed, you will be able to succeed for quashing the entire order. If you say 142.1 notice not signed, ठीक है, अगला notice आ जाएगा sign करके. That will not lead you anywhere. So you should know where to hop, where not to hop, what kind of thing you have to take in. See, the next decision which I have quoted here is of a Supreme Court in case of Rajesh Javeri. I think everyone is aware of this. This decision is just to state that what do you mean by assessment? Whether intimation 143.1 per se is assessment or not. What is the problem of assessment? है भी नहीं है तो क्या? What problem? What difference does it make? There are so many places in the act. It talks of giving interest. It talks of doing reopening. There the word assessment is used if the assessment has happened or not. So if it is only 143.1, the consequences of that 143.1 as if there is no assessment. So your assessment is only if there is a 143.3, 144, 144B and all those things, not 143.1. 143.1, though in common parlance we say summary assessment, yes, that's fine, but legally it is not regarded as assessment because there is no application of mind from the officer on any of the issues. They are restricted on the point which I will take you when I will take on the subsequent slides. Sorry. So these are the sections. I have just given the comparison between old and new. More or less it remains same. What was there in the old remains in new. Few flavors added in the new 2025 Act I will take when I will take that specific section. This is the income tax authorities which was there in earlier 116. Now new section is given 236. It is also more or less same, no change in that. Now first I have taken the summary assessment. See, summary assessment 143.1, again a very important thing for all the practicing chartered accountant. I will take you through this. I am just telling practically what is happening. Many clients receive 143.1. You have, if there is a demand or refund situation, loss situation, in many cases you will receive 143.1. Sometimes typical type of adjustment is made. We don't take any action against those 143.1 order. See, practically speaking, there are various litigation going on. What is the fate of this 143.1 if there is a subsequent 143.2 and 143.3? Whether this order gets merged into that order, whether this order will stand on its standalone basis and you have to take action. So in practically, if I will take the summary of all those cases when I have this thing, but the thumb rule is this: if any cause of action arising from 143.1 order, irrespective of what is happening in 143.3, you have to take an action. If you don't take any action, you are gone. You will be then at mercy of the officer who might pick up. If pick up, who might raise up this issue. We don't know whether that will be limited scrutiny. So that issue might not even within his purview and all those things. Then if you go in court against 143 order, court will say, look, the cause of action is not this order. Practically, I have seen not even individual clients, all MNCs. This is okay, no 143, we will see 143. And then ultimately matter went till court. Court says, look, court, when I say court, I'm talking about tribunal. Tribunal said, look, I'm a creature of the act. How can I give you relief against 143 order when there is no mention of anything in 143 order? Everything is in 143(1). These are two different orders. As if, let's assume for a practical this thing, there is a 143 and there is a 147. You don't go in appeal against the 143 edition. Now if you go in 147 will start with 143 and then separate edition. Now whatever there in 143 order you want to argue in 147. Is that permissible? That is why we have a separate order. You have to take action against that order. If you miss that bus, it is practically very difficult. In fact, in so many places, we have to advise our client, file appeal along with condonation. Otherwise, this is a dead claim for you. You will not be able to revive this claim. Second option is rectification. But again, rectification, rectification when we file, you will get the same order. CPC doesn't apply their mind. Sometimes we want to take a benefit of that. Let's assume we missed the bus. Time limit to file a rectification is 4 years. We will file a rectification, they will immediately process and give it to you back. From that order you go in appeal, so that your condonation and everything will be saved. But again, because no one is aware, in the order it doesn't talk of claim coming first time from here or it is continuing from the old order, so you might be saved. If they get to know that assessor is trying to take some kind of benefit from here, while doing this they might amend something, and or CIT comes to know, look, there is something underlying order and first time the issue was in that order, so this is not the first order and therefore they might deny it. So that is the risk there, but nevertheless rectification is only used for this purpose, because otherwise they don't have power. In fact, in 2025, that is of no consequence. That goes nowhere. That will only help you to save the demand. So he is asking about, there is an outstanding demand response column there in the ITBA portal or your income tax portal. That is only will help you to save against the demand which they have levied. So if you say our response, there is a demand of some 30,000 rupees. You say, look, my rectification is already pending, and if you rectify it, the demand will go. Says okay, so your demand is kept in abeyance. That will not help you to get it rectified. For appeal, appeal you will get the effective remedy. In rectification you will be in the loop. You might not get the relief. So it is always advisable, follow both the options. You don't go. Correct. But as I said, if CIT will come to know that, look, there was a first 143(1) order in which this cause of action arises, and now this is a rectified order, the scope of rectification is very limited. How it is a rectifiable issue? Now you are arguing on merits of the case. So he will say, I am rejecting your appeal because first of all it is not arising from this 154 proceedings, and you in 154 has given so many things, this is not mistake apparent from record, and therefore your appeal is dismissed. So again, there is a risk, but nevertheless, yes, practically this is one of the option available if it doesn't come to the knowledge of the CIT bill, because the way it is processed again in 154 is as if it is again processing the return itself. See, 143(1) again, the law is very clear, though it has gone change over a period of time. So many times there is a change in law, but law, one thing is very clear, that no debatable issue can be added in 143. This is first and foremost principle. Second, only 5 or 6 items listed in 143(1)(a), Roman 1, 2, 3, 4, 5, 6 can only be added. If you go and see those which I have listed here, if you go and see that and marry with your 143(1) assessment, if it is not fitting in arithmetic claim, inconsistent with the return of income, already not qualified in the tax audit report, but you have not made disallowance, a claim made which is not otherwise permissible if return is not filed within time and all those things. If your case is not falling in any of these, you can straight away challenge that order on the ground that it is beyond the powers of 143. So in fact recently, last month itself again a Bombay High Court has passed the detailed order on what is the scope of 143.1, whether a debatable issue on which you have to apply a mind to kind of view is permissible on that kind of issue will never come within the scope of this. In fact, there was a one clause here which they have deleted, which was creating a lot of problem, was 26 AS income. Straight away they were adding in 143.1. Sometimes without applying a mind whether that income is already offered, not offered, pertains to assessee, already offered in subsequent year, only a reconciliation issue. No, it used to be added, but they have luckily deleted that. So first thing, this you have to keep in mind. The second important thing which you have to keep in mind here is that if anything is made against you, there has to be a specific show cause notice. Giving you show cause that look, these are the additions, you give your reply. In fact, now their system is working very properly. Earlier, there used to be a situation wherein they don't used to send us show cause and make the addition in the 143.1 and the intimation used to be sent. The matter came up before the tribunal, and the various tribunal, including Mumbai tribunal, has taken a view that if there is a no show cause, opportunity of being heard not given, without taking assessee's contention on record, you made this addition, even though it is a summary assessment case, has to be quashed. Because there is a specific section in 143.1 which talks of this, you have to give a separate. So see, if you see the last one, no adjustment can be under section 143.1 can be made on an issue that is debatable in nature. Again, all other points, if you see, these are all repetitive points which everyone might be aware that 143.1, if you file a return and if your return there is no loss, no refund, no demand, your return per se is an intimation. You need not get a separate intimation. The second important issue which was going in this section was, which they have changed over a period of time, so many times, was what if the issue 143.2, whether still a 143.1 is necessary, or anyways there is a scrutiny which is going to go on. So before the passing of 143.1, there is a 143.2 itself. And in such cases, whether the refund which is otherwise eligible has to be given or if they can withhold. The law has changed in last 10 years, so many times. In what situation? Now it says you have to process the refund, but you can withhold the return, you have to process the intimation, but then you can withhold the refund with this approval of the commissioner. If you feel that there is going to be demand and commissioner approve, yes, there is going to be substantial demand, so they can withhold. But processing is now compulsory, has to be done, which is the new law as per the new provision. Now they have time limit to pass the 9 months, that is fine. Again, two remedies which we have discussed: filing of appeal, rectification, that is again same thing, I don't want to repeat. Sorry. Anything else anyone wants to know in summary assessment? Any query, doubt, or we can move to the next topic? So in fact, before moving to the next topic, transfer of files from which file? So in fact, 2025 September or August, CBDT has issued an instruction that the parallel right is given of rectification to the assessing officer. The assessing officer have a right, even for a CPC rectification thing, they can do it. So now no need to transfer a file. You can straight away go take help of this instruction and ask him to pass a rectification order. So this instruction doesn't talk of the assessment here. It talks of the right given to the assessing officer. So, obviously, I will take in my benefit. It's because this all is prior to this instruction. This instruction has in fact this was issued to address this roadblock. Otherwise, there was in fact, I will give you a practical example. See, ITBA is not the portal. There are so many portals in the department. There is some 360-degree portal. There is some CPC different portal. And all this portal is not sacrosanct. They don't match with each other. I have a case wherein some 500 crore refund was stuck. Why? The TDS credit which I have claimed in my return vis-a-vis what is allowed in 143(1) is that mismatch. Why this was mismatch? In my 26 years everything was proper. Every TDS was showing in 26 years, but it was not reflecting 360-degree portal. See, all this, again, whose problem? It is department's problem. They have to correct their system. But nevertheless, SSC was held and this demand refund was not given. In subsequent days, there was a huge demand and SSC was asked to pay 20% and everything. So again, I can understand the pain. This pain is real, but the solution is only courts. We can go to the High Court if your amount is this thing, and if you want to take the benefit of this, you will get the justice. But the time and cost is involved for this. If you are a small SSC, so in fact, this I was saying, sir has given the example of jewelry and everything. So in 2024, one case came before the Honorable Bombay High Court. There was some senior citizen who won this case from the department in 2016. 8 years, rigorous follow-up, no one was releasing their jewelry, not giving them. Now, when matter came before the court, the jewelry was kept by the income tax department in some, I think, Canara Bank. I don't recollect the bank exactly, but I think it was Canara Bank. And the Canara Bank people went, they opened the locker, there was nothing. Now, department came before the High Court. This is a case of Bombay High Court. And Canara Bank came before the Bombay High Court. Now, this all is a real pain. Now, the person who is standing there, he is saying, sir, ye jewelry, he was very senior citizen. He is saying, I have a attachment to this jewelry. There was a value and everything, and which was in current rupees, it was coming to some 50-60 lakh rupees. He says, money is fine. I have attachment to who has taken this. So after almost 15 or 16 hearings before the High Court has passed this 6 different orders running into 30 pages. Ultimately, they came into conclusion that, look, we can understand your pain, we can understand the value of the inherent value or intangible value of this jewelry, but nevertheless, only what we can do, ask both the person, department as well as bank to bear this 50-50 and give this money to the SSC. SSC got this. This all is the practical problem, but nevertheless, as a chartered accountant and as a service to the client, we should advise the client what is the practical way possible, and ultimately if something is not moving, and if you see the cost benefit analysis, ultimately this can be handled from the High Court only. Let's go to the High Court. If not, then you have to say this is the litigation cost which is there in India, and everyone has to go through this. In fact, so he must be passing the rectification order. So go to CP Gram, go to the one desk is there in the ICAI Bhavan. I forgot this thing. There are in fact 5 or 6 procedures laid down. You follow all the doors. You see ultimately what best you will get the denial through a rectification order. You can go and appeal against that. That is the best thing. If you knock all these doors, they will listen. In fact, the sir was saying CP Gram is working very properly. Yes, it is working. But again, if you see the practical thing, we have used the CP Gram maximum. You know, this all may be aware, there is so much of pendency before the faceless CITP. The cases as on 31st of March 25 is 5,93,000 cases pending in the CITP. It's huge. The High Court, the tribunal जहाँ पे pendency 1 लाख के ऊपर होती थी is only 22,000. High Court only 34,000. Supreme Court only 6,000. I'm talking of income tax cases. So if you see 22, 34, 6 vis-a-vis 5,93,000 cases. So we have gone to CP Grams for many cases. Look, this is the case of physical CITP. Kindly transfer to physical CITP. So many cases. TP issue, international tax issue, let him go there. What reply? So they again, because everyone is aware it is monitored from the PMO. So there is you will get all the audit trail, the file reply and everything. But the solution is very slow. Very slow. सब लोग हिलेंगे. But the desired solution you will only get from the appellate route, because there someone is aware what is the pain at ground level. But again, as I said, everything involved, cost and time is involved, but you have to educate your client. This is the fate of the tax system in India. We can't do anything much beyond explaining what is law and what is the practical ground reality which is happening. So, in fact, sorry, yes sir. Yes, sir. my mind, it will be a debatable because matter went till Supreme Court. Okay. And in fact, now all tribunals are deciding this issue in favor of the SSC. But nevertheless, before debatable and everything, whether it is falling within these 6 criteria. Yes, yes. But the point is this: आपको सब चीज चैलेंज करके ही मिलने वाला है. प्रॉब्लम वो है. See, if your client will come, इसे सर क्या है आपका तो रिटर्न का फीस गया, असेसमेंट आपको असेसमेंट भी कराने के लिए अपील भी फाइल करना पड़ेगा. That is the pain. The simplest of simplest thing, smallest of small thing, you have to go in litigation, and someone, if you go in faceless CIT bill, you don't even know. So I will tell you practically what is happening. The few faceless CIT bill who was also given a joint responsibility of a DR, department representative before the tribunal. So they were my friend. This is Nikhil. We got a target of passing a 500 plus order within this 4 months. He met me in November end. So what we are doing, we are taking all the cases wherein there is no request for VC and which we can dismiss by closing our eye. This is the fate of faceless CIT bill. What relief you will get? Again, you have to come in tribunal for smallest of small thing. And tribunal also, sir may be better able to tell. He has more experience than me. From last 2020, again I am taking away from my topic. 2021, there was one provision came for appointment of tribunal. This reform came for all the tribunals. Who can be a tribunal member? 2021 onwards. And there was 2 criteria. All may be aware. One is accountant member. One is a judicial member. Accountant member who was a CA having a 10 years of experience can be an accountant member, or an income tax officer who is 10 years of experience, or a judicial member is a lawyer having 10 years of experience, or any magistrate judge, lower court judge who is having 10 years of experience. When this 2021 reforms came, this notification in the form of notification, subsequently it was codified. They have raised the bar. For CA, it is now 50 years minimum age criteria. Okay, and you will get only for 4 years. So no CA is coming. Who wants to be? If you are having any practice for almost 50 years, you are age of 50 years, your practice is so settled. Why you want to leave your practice and go to tribunal? That too only for 4 years, and after that 4 years you will get retired. You don't know whether you will be continued or not. So who is coming there? All IRS officer who is retired. 60 years के बाद उनको 4 साल मिलता है. So 60 years as a IRS काम किया, 4 साल as a tribunal member काम किया. So as I said, the justice, even up you go to this, they will. In fact, I am quoting from the Honorable Supreme Court order. This reform went into Supreme Court. Supreme Court quashed. So this is not in line with our earlier direction. And the Honorable CGI was quoting in the Supreme Court. These judges who were earlier in department, who were sitting on the court, their remark was, "अरे इसमें तो हमारे लोगों ने भी appeal file किया हुआ है." So when you are sitting as a judge, you are independent. Now department is not तुम्हारे लोग. You are sitting as a judge here. So their conduct is as if they have given an extension. Now you are a department official sitting as a judge of the income tax appellate. With that approach, that mindset, they are sitting here. And if that kind of judge will come in your case, you can understand what kind of view he will take. He will not see what is the ground reality of. See, there are 2 sides. Some assessee might be doing a wrong thing, but that doesn't mean you will take same yardstick for all other assessee. You have to see what is the ground reality, how businesses are done. What are the practical challenges they face? What is the challenges they face in income tax because of your system? And then you have to adjudicate. But this is not the way it is happening at present because of this. Now again it is squashed, struck down. They have said it has to be in line with the lawyers. Let's 10 years. Let's see. Parliament has to come up with the enactment. They are going to come up in the coming year 2026. So we see if they reduce it to 10 years. So earlier it was a minimum age bar of 35 years, 10 years of experience. Then any CA can come and he will have life till 60 years. So there is a continuity. So anyone will come, a rational mind, a rational person who has practiced, who know what is the ground reality, how business works. So he will be able to adjudicate better. So again, that we have to see. So justice is this problem is there. So one thing I want to conclude in summary assessment, though I'm taking time, I know I'm exceeding, but I don't want to rush. Even if we complete 1 or 2 topics, that's fine, but we want to complete it thoroughly. See, 143.1, there are 3 kind of situation. Situation number 1, some addition made and you received 143.2 notice on this very same addition. Some addition made here in 143.1, you received 143.2 notice on same addition, you went in before the officer, explain. Officer understood and he dropped that in 143. What is the fate of action? What will you do now? Will you go in 143.1 because that is a separate order? Or here you can say the principle of merger will come into picture and you don't have to go in appeal against 143.1. The court says principle of merger will come into picture. You don't have to go against 143.1. But again, as I said, it all will depend on subsequent act. So at the time of 143.1 immediately file appeal. बाद में withdraw कर लो ठीक है. You can't keep your client hanging. ये हुआ तो ऐसा नहीं कर सकते. This is first situation. Let's take a second situation. 143.1 में एडिशन कर दिया. 143.3 का ऑर्डर पास किया. ये इशू उसमें पिकअप नहीं किया. उसने रिटर्न इनकम से आपका इनकम चालू किया और उसमें 143 के एडिशन करके उसने ऑर्डर पास किया. उसने भूल गया कि 143.1 का ऑर्डर था. You understood my scenario? What will you do? Will you go in appeal against 143.1? Or you will say no, there is no addition in the final 143 order, so why I should go in appeal against? The Mumbai tribunal in case of NSE, National Stock Exchange, and Pune, Kolkata tribunal in case of SRBC, they have taken away US. Again, a doctrine of merger will come into picture because 143 should have started with 143.1. 143 is final order. He has not made addition. Matter over. But only in these two scenarios. The third scenario, if he is starting with 143.1 and making the addition of 143 order, then it is a two separate cause of action. You have to file an appeal against 143.1 order. Fourth, if he same addition he is discussing in 143 order and he is saying okay, this I am discussing, but anyways it is already added in 143.1, so I am starting with 143.1 and making all other additions. Then there the cause of action is in both order. There you have still some case. If you don't file 143.1, you can still go in. So therefore, one more practical suggestion: if against 140 after 143.1 you have forget to file appeal, forget to file rectification, in your case is scrutiny, even though that point is not a point of contention in scrutiny, you file a letter on merits of the case on those addition in that order. Some cause of action will also be there in 143 order. You can file appeal against it. I hope I am making sense here what I am saying. Anyone wants to ask, or we can go to this subsequent slides? Anyone from this side? So this we completed. Now scrutiny assessment. First and foremost thing, there has to be 143 true notice within time. It talks of served, digitally signed within 3 months from the end of assessment year, or under new law 1 year from that. It has to be served. When you say served, see all this word have a different legal meaning, and it is all settled from the Honorable Supreme Court. What is the meaning of served? What is the meaning of issued? What is the meaning of passed? Served means, see, when you say issued, so 148 notice has to be issued, means it is beyond my control. So if I have uploaded in the portal, it has gone out of the electronic control of the income tax department, it is issued. When it is gone and it is received by me in my system, then it is issued to me. So again, it's not that in the old law when it was used to be served from the this thing physically, the yardstick was when you have given it to the postal authorities. So let's assume 31st of March 2026 is the last day to issue, then it has to be given to the postal authorities before that, so that it has gone beyond my control and it has been issued. So now in virtual era, you have to see that you received it within these 3 months. So practically this is happening now because of NFAC. They are very proactive, and this all things goes from the one person centralized authority. So I have not seen any challenge here, but nevertheless that is one of your important right which you should see. Otherwise you can challenge the validity. You can challenge the validity of search order also on the same ground of 143.2. You can challenge the validity of 147 also. But in all those cases, if it is other than assessment, in that proceeding you will get an opportunity to file return. In block assessment you will get, in a reassessment you will get, because you have to file a return in pursuance to 148 notice. If you don't file that your return in that particular this thing, then you miss that opportunity. Then you can't challenge that I have not received 143.2. You have to file return. If you file the return, you have to get a 143.2 to scrutinize that assessment. And if you don't get that within the time provided in the act, matter is over. This hotel Blue Moon is the authority for that. They have discussed this in greater detail and said yes, it has to be there. Otherwise, you can't proceed with the assessment. That is the first and important point. It has to be there. Legally, it has to be correct. So there are so many things, even in fact, happening. There is a decision of a Mumbai tribunal in case of a DSV solution argued by Mr. Mistry. The issue was, I have given my address copy to the department, and subsequently while filing the return, I revised the address and file in the return of income. And if you see the rule 127A, it talks of communication address. I myself, I don't know whether I'm going too much into the nitty-gritties, but nevertheless, these are all important points we should know so that we can challenge whether I have this notice or order per se is right or wrong. See the smartness of the case and counsel here. The department has issued the notice or the order in the old address. And one of the manner of changing the address is if you can change in the return of income itself. If in the return you file they have sent it to the old address. The entire order was quashed only on this ground in the case of Mumbai Tribunal, in case of a DSV solutions. So again, it's not only about serving, it's not only about proper manner of service. In fact, one more matter came before the Honorable Bombay High Court, wherein wrong email ID. There were two email ID given, earlier email ID and subsequently, and they have rectified this subsequent email ID, and the email was sent to the wrong email ID. The issue was whether the notice given on wrong email ID, there was the only mode of communication, whether it is right or wrong. Bombay Court says no. Subsequently, it is rectified. So all the basic important facts has to be noted down, and you have to see whether department is complying with this. And for all those things, now there is a rule in place. You have to see this, and if they are missing anything, you just first have to think yourself whether it is a fatal defect or it is a defect which we can cure. If it is a fatal defect, then you have to take a ground at whatever stage you are. That's proper fine, because 143.2 doesn't prescribe what all you have to do. That is the only initiation point. In fact, even if they don't want anything, they still can continue. In fact, there is one recent controversy which is going on. See, in 2017, in fact prior to 17, every year the department used to furnish a format of 143.2. In fact, I have noted somewhere in my slides, I don't know where, because I got very less time, so I don't remember where I have mentioned, but it is there in my slide. So what has happened there, prior to 17, every year department used to say a format of 143.2, and there was one important legal right given in that format. The scrutiny can be of 2 or 3 or 4 types. One, limited scrutiny. One, full scrutiny with the physical verification. One, full scrutiny. These 3 component has to be there, and you have to tick mark which is the component on which you are selecting and give that 143 to the assessee. So assessee is aware that, oh, my case is selected in this. If it is a limited scrutiny, so he can ask only question on those points on which it is selected. If he wants to go beyond that, he has to take the approval of commissioner. If commissioner says yes, then only, otherwise only on those ones. So 2024 matter came before the Kolkata Tribunal. Says, sir, this is the last available instruction in the portal, in the government records, in the official records, in public domain. There is no other information or subsequent renewal or format. And look, my 143.2 notice, which now comes from the NFAC. It's simple. It doesn't talk of it is limited this thing. Therefore, the important right given to me has been taken away. Now, how I will know if it is limited scrutiny, full scrutiny? The DR argued, sir, I have taken a report, it is full scrutiny. It is not to be told you post facto. It is to be told to me before selection of scrutiny, so that I know what is my right, what kind of question will come, and how I should prepare better before the assessment proceedings. Kolkata Tribunal quashed this. 143.2 matter. In fact, there are more than 20 orders from the Kolkata Tribunal, because there is only 2 or 3 benches, so every matters come before the same kind of bench, and normally council gets aware this is the legal view coming. Matter went before the Delhi tribunal. Delhi tribunal started causing, 2 or 3 members started taking this view. Matter came before the Bangalore bench. Bangalore member says no, this is a curable defect. 292 BB will come into picture. It is not something fatal. And this is, we are not agreeable to this view. Let me refer this matter to the Honorable President for constitution of a larger or special bench. Now that special bench is constituted MD Sons, which is fixed on 9th of Jan. Mr. C. Padam Chand Kincha is appearing for that. In fact, there will be lots of intervener here, to my mind, because this is the position for all assessment from 18 till now. The format is this. In fact, for 1 or 2 my foreign clients, I could see, though it is not in format, but this tick mark is there, which is the basis on which scrutiny is selected. How we have to see how this is mitigated. Otherwise, this will be one of the largest controversy ever. In fact, I have listed one more controversy, which is the India's biggest litigation controversy. I will discuss, though it might not be of very much interest because it is pertaining to the international tax, but still, it will be one of the largest litigation controversy wherein all your assessment order from 18 or 17 till now will get quashed only on this ground. All your 143.2 is invalid. So we have to educate our client. Depends on what is the fact, what is the legal provision involved. We have to take such kind of provisions. So in fact, again, there are so many things. If your client's place got transferred from one place to any other place. Now again, this is in fact earlier there was so much of litigation on this, and many chartered accountants are not aware. Let me speak 1 minute on this. So I have to complete by 1:30, correct? So I might miss some of the points, but I don't want to rush and half cook. I don't want to give any half cook story here. So earlier, always this question used to come to all the CAs. In fact, when we were also struggling, and so many positions from tribunal, if a particular SSA is in Mumbai and he went to Kolkata, his case records has to be transferred or not to be transferred, and subsequently the assessment order passed, or he was in Mumbai, order passed, and now he went to Kolkata. What is the where his case will come? Whether he is to be assessed in Mumbai, Delhi, where, or if it is happening so many times. What if there is merger between two companies? Now the assessment happened at Ahmedabad. He got merged into the Mumbai. Now it is everything is in Mumbai. Appeal was pending in Ahmedabad. What is the fate of everything? So many issues, so many controversies. In fact, there is a Supreme Court. It's a basic thing. This has to be kept with you. Supreme Court in 2023, ABC. Case name is ABC only. It's not. I'm giving a ABC Limited. It says at the time of passing of assessment order. Forget. पहले कहा था, बाद में कहा था, भूल जाओ. जिस साल का assessment order is in question, at the time of passing the order, where your officer is situated. In a faceless era, if you don't know, because it is faceless, so at the time of passing of order, where you were situated, that is the place where your all litigation will go on till High Court. Now, keeping that aside, if your case record gets transferred and new officer from the new location comes into picture, he should issue a 143.2 afresh to take a matter in charge, even though there might be a prior 143.2. Or if there is otherwise case 143.2 selected at one place is matter transferred to another place, no 143.2, Kolkata High Court says. Because the officer who is passing the order, he never issued you 143.2. The officer who issued 143.2 is not your officer. So again, all those things has to be kept in mind. So again, this was the instruction, and if you see the bottom, the special bench MD Sons is mentioned on 143.2 type, and there are these few tribunal order I have given here. Now, because the topic was given on the timeline, so I have also given the timelines. What should be the timeline? See, I can understand the topic is very boring, but I will tell you, because see, income tax, कोई स्टूडेंट भी होगा, कोई सीए भी होगा, बोले हाँ टैक्सेबल है कि नहीं है, ये बताओ, इसमें मजा आ रहा है, इसमें हमको. But I will tell you, believe me, when we are in litigation, we spend our maximum time in procedure. So that it's not only about particular amount is taxable or not, whether it is collected in a right manner or not. And if it is not, you have so many avenues available. So in fact, I have also listed here NSE order, which I have discussed just now. In the NSE order, 143.1 addition was made, 143.3 addition was not made, doctrine of merger was applied, and everything was passed. So I'm not going into timelines because it is there in the slides. Anyone wants to look into this, they can look into this. So before going into the best judgment assessment, again I will take 2 minutes only. I will not spend much time here. The controversy which I was mentioning with the permission of this, because again, so one of the I will say in terms of value, it is into the some 1 lakh crore rupees stuck in one of the litigation because of this procedure itself, which is challenged by the councils and matter is pending in Supreme Court. Everyone should be aware, and I will just briefly give, not more than 2 minutes, I will explain the controversy. See, there is a decision of Bombay High Court in case of shelf drilling, and Madras High Court in case of Roka bathroom. This, last year, in fact in this year itself, there is a decision from the Supreme Court split ruling. One member in favor of the SSC, one member against the SSC. Matter is referred to larger bench. If this ruling comes in favor of the SSC, they have challenged the validity of all the assessment order passed through DRP route from 2009 till 2025. Still department is doing the same thing. 16 years, all international tax SSC, all transfer pricing SSC will go. And it is the tax impact involved, it's given in the SLP of the Supreme Court is some few lakhs crore rupees. It will go just because of this procedural lacuna. The procedural issue here was, see, if you come to a DRP provision, DRP says draft order is mandatory. And practically, if you see, department passes the draft order within the time limit which is given for passing the final order. 153(1) में जो time limit है, उसी में वो draft order pass करते हैं. And thereafter, they take 9 months for passing a DRP order, then 1 month for passing a final order. The SSC's argument here is that everything should come within 153. You can't say the 153 में तक तुम खाली draft pass करोगे, फिर extra तुमको 11 महीना मिलेगा. 144C has to be subsumed in 153. So आपको ड्राफ्ट ऑर्डर 11 महीना पहले पास कर देना है 153 के टाइमलाइन से, फिर वहाँ से आपका 9 महीना डीआरपी, सो दैट और फाइनल ऑर्डर है आपका वो 153 में आना चाहिए. क्योंकि फाइनल ऑर्डर पास करने के लिए इनकम टैक्स एक्ट में सिर्फ एक ही सेक्शन है 153. अगेन the procedural thing only, but this because of this, in fact, this is the first ever litigation because of which all cases in tribunal across India is stuck. There is an instruction from CBDT not to pursue until we get settlement from Supreme Court. Otherwise, what will happen? Tribunal will pass order in favor. They will get all the refund. All the refund will come into the SSC. And what High Court, Supreme Court, 5-10 साल तक जब तक आएगा तब तक आएगा. He said, department is walking away. They are not arguing the case. That is the instruction. So why I am highlighting this? I know this might not be very relevant for this forum, but this just to give this thing that you should know that it's not, as a chartered accountant, we should not only tell the client about taxability per se. The procedure of assessment is a very important thing. It gives you very important right, and if that is not done properly, you have to challenge, and you can help your client to mitigate tax liability even in this situation. But two things you should keep in mind. One, Supreme Court decision in case of a Shelley product. It came in 2003 or 4. Here again some important, some chartered accountant has advised client, look, your assessment got quashed for whatever reason. So now go and ask for refund of return tax also. Supreme Court says no. If assessment is quashed, it will not go nullity from before return. It will go nullity even just after return. So your return and your self-assessment tax, whatever you assessed, will be there. You can't go beyond that. First thing. Second thing, whatever legal point which we are discussing here, again, all are my personal view basis that, but there is a section in the Income Tax Act which says you have to point this out within 30 days. If you don't point out this before the officer, you take first time before the appellate authority, then you will have to have a case to explain there. So now here, in fact, there are a Bombay High Court which has given a via media. They says if a particular legal argument going to the root of the matter, and because of that entire order is getting quashed, that 30 days rule should not come into picture. But nevertheless, it is always advisable at the first available opportunity, put this before the assessing officer, so that no one can say that you are taking an advantage. You might be aware and you have not taken, and you are only taking before the appellate forum. Though practically everyone does that, but this should not come in your way. See, best judgment assessment, everyone is aware. Three condition not fulfilled, you can take for best judgment assessment. Now, one important amendment in best judgment assessment, now CITPL has got the power to remand the matter. So, after 2000, 1999 or 2000, the CITPL के पास remand का power नहीं था. They used to call a remand report and they have to adjudicate yes or no. They can't say no, I'm sending it back to the assessing officer, he apply his mind afresh. That power was not there. But only against the 144 order, best judgment, that he got the power. And all other things are routine. I don't think so I should spend time here. In fact, more than me, you guys will be aware of how this happens. I have not done this case is very practical, and in what situation you can reject the books of accounts. If that condition is not, whether you can, after rejecting books of accounts, you can again look into that books of accounts for computing. There are various positions and all are almost settled. Situations are listed. You cannot go beyond that situation, and once books rejected, it is rejected for all. You cannot pick and choose one or two items from here, then you have to apply. One important principle in best judgment assessment, you have to have, just because everything is rejected, you can't say I will take anything and everything. The rationalness, fairness, everything has to be there. That is what the court says. Protective assessment, again, one should keep this in mind. Practically this happens, this thing. See, protective assessment and substantive assessment normally comes into picture when two things are not clear. Number one, if department is not clear whether it is income of Nikhil or income of Mr. X. So, if his stronger case is Nikhil, he will say substantive assessment in the Nikhil and protective assessment in Mr. X. So that in future, if Nikhil's case is no, it is not Nikhil's income, he will have right to tax in the case of Mr. X. Protective assessment, he can recover the tax from me, जिससे substantive किया है, जिससे protective किया है, उसे tax recover नहीं कर सकते. उसको खाली assess करके आप छोड़ दो. जब मेरा finality होएगा उसके appeal में तब वो decide होगा. But क्या ना, जैसे lawyers go in court and CS goes in court, they argue various kinds of things. So again here a catch is this: if in a protective assessment and if a substantive assessment is quashed for any legality, so if I went before the tribunal and says, look, substantive assessment order is time barred, it is passed beyond duty, then in such a situation you cannot go and add protective, because substantive के हाथ में मेरिट पे तो कभी डिस्कशन हुआ ही नहीं, क्या पता है उसी का इनकम हो, आप substantive को पकड़ नहीं सकते. Substantive will always follow by an order wherein protective is set. Protective will always follow by an order in substantive wherein it is held that substantive is not taxable in his hand because of XYZ reason. Therefore, it will come to me. If that order is not happening for any reason, substantive. It's not that protective का order quash हो गया तो straight away substantive पे आ जाएगा. नहीं. Protective के हाथ. This was the first situation. Second situation is if officer is not sure about the year 1 or year 2 or year 3 of the same assessee, he will add in year 1 as a substantive, year 2 and 3 as a protective. But again, substantive you can recover the tax demand, in protective he cannot. Again, this is not defined anywhere, all judge-made law where the courts have given the thing. So various rights and responsibilities. Again, I have, as I said, I am coming from the controversy background, so I have listed on few controversy. I have discussed many of them. I don't want to repeat. I am giving this case laws as far as the assessments are concerned, so that you can see one of the important controversy which is going on. Order passed in the name of non-existent entity. Keep in mind, if there is a merger and everything, order has to be passed in the name of entity who is in existent. And your right is, your responsibility is, you have to inform the officer immediately after the merger. And even after the information, if he is not passing the order in the name of new entity, your order is void ab initio. Maruti Suzuki Supreme Court says this. There is one more Supreme Court, Mahagon Realtors, which came subsequent to Maruti. It says if you not inform an officer pass in the name of wrong entity, then it is right. This is not relevant. Now I will just briefly take on DRP process. I have just explained the controversy. I don't want to go in DRP. I will just 2 minutes I will take on reopening. I know it was the important topic given to me. Again, faceless assessment. See, I have so many things to speak on faceless assessment, but that is topic in itself. If you see these, how the faceless came into picture, how it was codified, what was the right given now, what is the right till 21 to 22, and what is right now from 21 till now is altogether different thing. There are 5 units, all have a different right, and at any point of time, you feel all the 5 units is exceeding their scope in their right, you have a challenge there. So for that, we need to discuss all the 5 units rights and responsibility. In fact, we have developed few arguments, but nevertheless, as I said, that is topic in itself. If you want to speak, I need a 2 hour session for this, so we can complete. But I have listed few of the controversy here because I know this PPT will come. If anyone wants to look into this, they can look into this. Just 2 minutes. I will just combine this up. Sure. So I have listed how before 22, before 21 on faceless everything comes. So because faceless में भी बहुत सारे controversy थे. पहले draft order आना चाहिए था, वो उसको हटा दिया उन्होंने. तो draft order नहीं देते थे तो उसका क्या consequence था, हटाने के बाद क्या consequence है. हर एक unit, regional unit, verification unit, reference unit, सबके powers change किए उन्होंने over a period of time. What is the meaning of that? Whether उसके पहले वो powers थे नहीं थे. So all those things I don't want to spend because video conferencing is also, as I said, I have just given the example of CIT people what they feel about video conferencing. Video conferencing is an important thing. We should discuss this with client. See, after you do a VC, you will get a link of VC. That video, whatever you spoken during the course of hearing is recorded and you get that VC. Always keep that link, download. If it is downloadable, keep it with you. It is an evidence which you can present before the court. Court will ask, look, have you argued this? It is not in your written submission. Screenshot. See, I have argued. You can take that video during the course of hearing. This was argued before the lower authorities. So always ask for a VC link once your VC is over and just go through so that at least you will note it down, everything you have argued, and you can use this as evidence at the time to come. So here, just considering time limit which we have in mind. See, reopening is now one of the debatable, tactic or difficult law which we have as on today. If you see the time limit, they have changed from so many date to so many date. Now the present time limit is 3 and 5 years only. But even in 2025 Act. But if you see the 25 Act, you will see the 4 and 6 years. Because new act doesn't talk about assessment year. It only talks of the tax year. So it is a previous year. So it is therefore 4 and 6 years. Otherwise from the assessment year, it is 3 and 5 years. This is one thing which you should keep in mind. 2022, only basic thing I'm explaining because if I speak on so many things, thereafter I have taken 50 slides on the cases on how everything is happening in reopening. Reopening is mess, totally mess. So if you see, when there was a Supreme Court decision which was protecting the right of the SSC on, in the case of reopening, how reopening should be conducted. The procedure was a judgment law that after you file a return of income, you will get a reasons for reopening. After getting a reasons for reopening, you have to give your objection. Officer has to dispose your objection, then only he can proceed with the reopening. This was the judgment law. GK and Drive Shop, Supreme Court has given this long back. Small order, half-page order, but this was law which was continuously followed. 2021 they codified this law, and there comes this section 148 capital A. This is still there even in 2025 Act. But 22 to 24 they had so many problems because the 148A process, which is a process of disposing the objection in the old way, there was so many time limits applicable there, and the department was always missing that time limits. There are so many writ pending on that point. So therefore in 2024 they come out with the time limit for 148A also, which was not there earlier. That time limit was 3 year and 5 year. And main 148 section time limit is 3 year 3 months, 5 year 3 months. Which is the time limit which you have to see is 148 notice is 3 years 3 months. So this extra 3 months which they have taken is only because in those 3 months you complete your 148A process. That is also there in the new act, and just wanted to make you understand that this they have goofed up earlier in 2, 3, 4 years. So just to give department extra time, they have come up with this 3 years, 3 months and 5 years, 3 months. Earlier only was 3 and 5 years. So this has to keep in mind. Your reopening time limit is not 3 years, 3 months and 5 years, 3 months. In fact, now I have given various things which is slightly changed in new income tax act. If I take you through one by one, it will take its own time. I have listed there. If you see this column, last column here we are only discussing about what is the new change. That is not very material, but few change here and there makes the entire thing. This thing, only one example I will give, and then I will wind up. So here, so the new 148 provision, earlier you can do reopening on anything and everything if you have a tangible material. Tangible material was subject matter of dispute before various courts of Supreme Court. Supreme Court has taken a view. Tangible material must be something new which was not there before the officer, and he has come to knowledge subsequent to the assessment, and he can use. Now this reopening is on the basis of information. Information is defined exhaustively, not an inclusive definition. You have to see 1, 2, 3, 4, 5, 6. If it is in this 6, that is the information. When it section this came in 2021, the information के अंदर एक उन्होंने clause डाला था. Information means information arising out of any of the code or direction. Now there was so much of confusion. Now again they have some. I am just giving this one example to say that how this is. Now the information is not the court order. Information means information arising out of any court or this thing. So आप बोलेंगे नहीं ट्राइब्यूनल का ऑर्डर आया तो ट्राइब्यूनल का जो फाइंडिंग है वो इन्फॉर्मेशन हो गया. नहीं, उसके लिए एक अलग से सेक्शन है 151. ये कोई इन्फॉर्मेशन इज अराइजिंग आउट ऑफ कोर्ट और ट्राइब्यूनल ऑर्डर. नाउ व्हाट इज द मीनिंग ऑफ दैट? सो मच ऑफ कंफ्यूजन. In fact, there is a 151 which says any direction contained in the court order, for that there is no time limit. You can go for any number of years. That is a different thing. Now in 2025 उसको उन्होंने modify किया. 151 वाले section को भी यहाँ पे information में लाके डाल दिया. Now entire thing is खिचड़ी. You will not be able to understand whether you for any tribunal order, whether you need any information which should arising from that tribunal order or that tribunal order per se is the information. Again, scope of litigation. Things is not clear. If you say next 10 years, this is going to give so much of litigation. In fact, 21 से 25 में ये settle हमने किया, change of opinion का concept अभी भी है. So the way it was looking, they have given up the concept of change of opinion, but the courts is saying Siemens, Bombay High Court, Karnataka High Court, Kerala High Court, Delhi High Court, in no clear terms, change of opinion is still there. Again, you are aware that now the reopening is on the one of the key criteria is risk management strategy. This is a very dynamic thing. There is a team of officers who is only gathering the information from various. Sir will be aware of more because he is closely working on search. From all the search, all the investigation being FTR, say जो भी information आएगा, that team is sitting and uploading that in the system. And basis that your risk management strategy is dynamic, it will come every time. ईयर 1 जब आपने रिटर्न फाइल किया, जब आपका स्क्रूटिनी हुआ, वो रिस्क मैनेजमेंट स्ट्रेटजी में नहीं था. आपका रीओपनिंग का टाइम है 5 साल के लिए. 5वें साल में अगर रिस्क मैनेजमेंट स्ट्रेटजी में आ गया, योर केस विल बी फ्लैग्ड ऑफ, यू विल बी सिलेक्टेड. So many things goofed up, but because of this, the point was if he has examined this, even though it was not in risk management strategy, if he is examining the assessment, can I still argue? Because the concept of change of opinion was arising from the word reason to believe, which was there earlier. Now reason to believe word is taken away, but court says no. Still, how can a same officer examine the same issue twice? Once examine and allowed, now second time examining and saying no, I am not allowing. Whatever may be the circumstances, whatever may be the risk management strategy, it cannot happen. Otherwise, it will lead to a situation wherein the taxpayer will not have trust in the department. And therefore, in these 5 years, one of the important thing which is settled is change of opinion is there. Now in next 5 years, this all small. See what happens when any cases goes in litigation. No one goes only on the one argument. Everyone will list down all the 10 arguments. But what they will argue, the important 1, important 2, important 3. Whatever I am explaining about so many things they have goofed up. This is there in all the litigators list. But now let's assume in a particular case where in the important argument 1, 2, 3, 4, 5, 6, 7, 8 is not there, only 9, 10 is there, then that will be tested before the court. So next 5 to 10 years you will see so many development in the reopening. So my humble submission would be, if any reopening case will come, please examine this thing and always argue, put your client's facts and always put an argument from the start, whether there's an information or not. So much things there in the information. And I think many of the cases you will be able to succeed only on the definition of this information. I think we can speak even, but let's conclude this. And that's all from my side. If you have anything or any specific points which you want to discuss in this, we can discuss. Otherwise, I will wind up the session.
Thank you, sir. I think I thank the members who sat till this time. Very, very important topic sir has covered in a very crisp manner. आप सबको पता है बहुत बड़ा टॉपिक है, 1-1.5 घंटे में कुछ कवर नहीं हो सकता है, तो we'll wrap up in a minute. Vote of thanks, which is very well deserved. I'll just request Nikhil sir to come and sit on the dais, and all of you just wait for 45 more seconds. Sikandar, please give the vote of thanks, which is really deserved. First of all, sparing his personal time to us and sharing his wisdom and the experience of 18 years into litigation. That's very important. And I think both the speakers were on a practical aspects rather than the theoretical aspect. That's what very important, what I liked in today's session. Over to you.
Thank you, ma'am. It is a great pleasure and privilege to propose well-deserved vote of thanks to CA Nikhil Tiwari. Thank you, sir, for accepting our invitation on the subject of assessment and reassessment. He has covered the subject with lots of detailed explanation with case laws and examples. The presentation was very interactive. He also answered to the questions asked by the members. We hope today's session has added enormous knowledge values. Now I request members for loud applause. Thank you, sir.
Wishing you all a very successful 2026, which we will be welcoming now. All the best to you all present here. Thank you.